There's a moment in every era of legal practice where a tool shows up and the profession has to decide what to do with it, whether to take it with them into the wilderness or leave it behind. The typewriter gave way to the word processor. The fax gave way to email. The library gave way to electronic research. The warehouse of bankers' boxes gave way to electronic document review platforms, and then predictive coding and technology-assisted review. Each one arrived with the same two voices. The people who said, this changes everything, and the people who said, this changes nothing. Both were always wrong. Today's tool is generative AI, and I don't think we've ever seen a technology impact the practice of law and the very philosophy of what it means to be a lawyer this profoundly. And for the first time, we have a randomized controlled trial measuring how these tools actually change the work product of the attorneys who use them. My guest today led that study. This is episode 24 of ESI Survival Guide. Before we begin, this podcast is for informational and educational purposes only. Nothing discussed today constitutes legal advice. The views expressed are those of the speakers individually and not necessarily their respective institutions or clients. Daniel Schwarcz is the Fredrikson and Byron Professor of Law at the University of Minnesota, Twin Cities. He's one of the country's leading scholars on insurance law and one of the most active empirical voices on AI in legal practice. Along with, and I have to give credit where credit's due, so I'm going to name all the authors, Sam Manning, J.J. Prescott, Patrick Berry, David Cleveland, and Beverly Rich. He's the lead author of the first randomized controlled trial measuring how next-gen AI tools, specifically reasoning models and retrieval augmented systems, affect the way lawyers do actual legal work. The paper is AI-powered lawyering, AI reasoning models, retrieval augmented generation, and the future of legal practice. And it's just out in the Journal of Law and Empirical Analysis. Dan, welcome to ESI Survival Guide.
Thanks. Really happy to be here.
Very excited to have you here. I saw this paper on a post on LinkedIn, knowing Maura Grossman really well and really being interested in all of the studies that surround these new tools as they come out. As soon as I saw that, jumped in, I read it. I knew I had to have you on the podcast. Thank you so much for doing this. I'm really excited about today. Let's jump right in. So I want to start with something you wrote in this paper. You said, and I'm paraphrasing here, that the legal benchmarks people are using to evaluate AI are becoming increasingly inadequate for measuring what the tools actually do. Because they don't really measure what humans with AI tools can produce. They only measure the AI alone, what the AI alone can produce. That's a pretty bold methodological claim. Walk me through how you arrived at that conviction, because it's really the foundation that everything else in the paper sits upon.
Yeah, no, that's exactly right. There have been a lot of benchmarks, and benchmarks are very important in measuring and evaluating the capacity of different AI systems in different domains. But at the end of the day, when you're dealing with professions that require, as a matter of custom, as a matter of ethical responsibilities, as a matter of practical reality, that require human engagement throughout the process, then what really matters when you're evaluating the extent to which AI is going to impact the profession is how humans use AI. And even if an AI system can do reasonably well at producing output that looks good on its own, that doesn't necessarily guarantee or ensure that a human using an AI will be able to produce those same results. Because, for instance, it may be more difficult or it may take longer to check the AI produced output than to do it on your own. It may be that when you're trying to expand on AI produced output to make sure that it addresses everything that needs to be addressed, you end up creating or introducing problems that were not there without the human involvement. And so I just think it's a very different type of question. What happens when you give a human access to an AI and have them work to produce output than when you simply prompt an AI, however, to produce output on its own.
Can you expand a little bit more so on this whole concept? I remember when GenAI first came out, I think one of the benchmarks people were looking to is, it could pass this bar exam. It could do this well in the bar exam. When you say benchmarks are saturated, what are you actually worried that we're missing about how these tools are used in the day-to-day practice of a lawyer?
Well, look, even if an AI can provide good answers on particular questions, it doesn't necessarily follow, for instance, that a human who has that answer will then be able to use it to produce good work.
Sure.
They may not, for instance, understand the answer themselves. They may need to do the work themselves. They may not be able to piece together different elements of the answer. And even probably more foundationally, a lot of legal work is pretty different than the types of questions that are being evaluated in these benchmarks. Most of these benchmarks are relying on objective questions where there's a right answer. And, most lawyers know that in many contexts, the answer is it depends. And the quality of the output depends on a broad array of factors that are difficult to measure objectively in the way that many of the benchmarks do. So to me, again, the benchmarks are valuable, and I think they're one piece of the puzzle, but I don't think we can say simply from the fact that an AI passes the bar exam with flying colors, that means that an AI is going to enable a human lawyer to do actual legal work of the type most human lawyers do better or more effectively without actually testing that claim.
Sure. And actually, it could have the opposite impact where AI can, in fact, get a lawyer out over their competence skis a little bit and put them in a place where, like you said, doesn't mean they're going to even understand the answer. And maybe that gives them a false sense of confidence that they know a domain where they actually don't because they asked Claude or ChatGPT.
No, absolutely. And look, that happens, at least anecdotally, that happens all the time. Whether it's AI hallucinating false materials, or whether it's AI producing results or output that looks right but is not right, or whether it's AI producing output that is right in one sense but doesn't fully address the issue or doesn't enable a human lawyer to work out elements that the AI hasn't dealt with or even prompt the AI well. So I just think there are a lot of questions when you're trying to extrapolate from these benchmarking studies to the actual practice of law.
The duty to supervise and the certifying discovery, those are going to be working overtime in this new era of GenAI. Dan, before we go deeper into the study, I want to know about you a little more. I want to know how you got here, because you're known primarily in the field of insurance as an insurance law scholar. That's a long way from running randomized controlled trials on AI tools. What was the moment or the case or the conversation that actually pulled you in to the AI side of this?
Yeah, I've been interested in AI for well over a decade. And the reason for that is it's actually an incredibly important topic in insurance law. One of the big issues in insurance involves when and how insurers can discriminate. And the basic framework in the insurance regulatory regime is to allow insurers to discriminate when they can show an actuarial justification, but then to have some pretty clear bright line rules about types of data that insurers can't use. And sometimes it's the obvious things, whether it's race or ethnicity. Sometimes it's factors that are less obvious, but that are actually really important because discrimination on that basis has, really negative side effects. So you can think about discrimination based on medical history in the health insurance context, or you can think about discrimination based upon domestic abuse in the context of property insurance, or you can think about genetic discrimination in the context of life insurance. And so in all of these different domains, there are a lot of very good reasons why we don't want insurers to use certain data and information, even though that information is very predictive in the sense of predicting the likelihood and magnitude of claims. And the difficulty that became clear way back before we were dealing with large language models, when we were just looking at sort of the predictive AI that used machine learning tools back in 2012, 2013, 2014, was that on the one hand, machine learning tools were very powerful at making predictions, and so as a result, very enticing to insurers. But on the other hand, and this was sort of where it just raised really difficult questions about how you are able to navigate the type of regulatory regime I just described to you, because AI systems, in some sense, or machine learning systems, to be a bit more precise, in some sense, find correlations that exist in the data that we don't even understand why, and that very well may be proxying for things we don't want to take into account.
Wow.
And so when you're using a machine learning tool to predict outcomes like how likely are you to file an insurance claim, you may not really know whether or not the model that the AI system is relying on is actually implicitly proxying for any of the factors I mentioned. And so that's how I became interested in it, really as a matter of insurance law, well over a decade ago.
I have about 1,000 questions now. So we'll say that for another day, Professor Schwarcz. I'm going to have to ask you back on to
Absolutely.
do a whole thing on that. And shout out to my friend Brent Stevens doing data law and insurance. I know his ears are peaking on this topic. Maybe we'll bring him on as well and have a conversation. But that's really interesting. I didn't think about that domain and that specific use case bringing you into this tech domain. It's amazing the different webs that bring people into the space. But help me in the audience map the lineage. You've now run a series of empirical studies on AI and legal practice. This isn't the first. There's ChatGPT goes to law school in 2023. You did a GPT-4 randomized controlled trial with Jonathan Choi and Amy Monahan in 2024. And the follow-up on AI assistance in legal analysis. And now this one, reasoning models and RAG. So walk me through that arc. What were you learning each step of the way? And did each study kind of set up the next one? Or was it more of a Jackson Pollock-y kind of random approach to it?
Yeah, I think that there's been a pretty clear progression. I mean, with the very first one, ChatGPT goes to law school, I mean, that was sort of, in a sense, a very early benchmarking study. Right as ChatGPT came out, we sort of thought, well, gee, like what can this new tool do when it comes to answering law school exams? And so we just fed law school exams to ChatGPT and graded the answers in the same way we graded student answers. And we got results that at the time seemed amazing, which was, oh my gosh, this tool can get like a C plus or a B minus on a law school exam. That's pretty amazing, right? Very quickly, of course, things escalated as the tools got better and better. They started being able to perform, pass the bar exam. And nowadays, I would say that most AI tools can probably get A's or A pluses on most law school exams, certainly if they're prompted with the right underlying materials. So that was sort of the first set of questions. And then I did move into the randomized control trials exactly for the reasons that we sort of were discussing earlier. It became clear to me that the mere fact that AI could produce output that looked good didn't mean it was going to fundamentally change the law,
Right.
And how the law was practiced. We needed to know what happened when human lawyers were using AI. And the only real way to test that, in my mind, is to do a randomized control trial, or at least the best way to measure it, where you have groups of participants who are legally trained, and some are using AI and some aren't. And you are varying that across tasks to try to evaluate, what the consequences of that are. So I moved into doing that in the piece with Amy Monahan and John Choi, which was published in the Minnesota Law Review. And then in this piece that was just published in the Journal of Law and Empirical Analysis, we really wanted to basically run a very similar experiment, but instead of looking at GPT-4, to look at some of the newer generation models, whether it was the reasoning models that had just come out or the Retrieval Augmented Generation models that a number of the legal tech firms are developing. And I'll even say in another paper that just came out that's not published yet, we even went further. And what we tried to do was evaluate the impact of using these tools, using AI tools on lawyering tasks once you take the AI away. And so we actually did a randomized control trial evaluating what happens if folks use AI to do legal research and to evaluate that. And then you take away the AI tools and you compare how folks who used AI in stage one perform once that AI is taken away.
You're working on that now. Is that one?
Yeah, we just put that one out a few weeks ago, and I'm happy
wow.
to share you with the link. Yeah, that one is called. Well, I need to remember the name of it. So one problem with doing as many studies as I've done is you tend to forget the names to the various.
They don't papers. Exactly roll off the tongue that easily. So
yeah, so that one is called Artificial Intelligence and Human Legal Reasoning, and that one we just put out in mid-April. So really, just a couple of weeks ago. Each time, to take a step back, in my mind, and you mentioned this earlier, in my mind, AI really has the potential to fundamentally reshape not only the practice of law, but most white-collar work. And I think in some ways, maybe the practice of law is more exposed, in some ways less, but it's just unclear. And so if you have this technology that has this much fundamental power and there's this much uncertainty, it's just really important to empirically evaluate. Right? Instead of sort of speculating, there's just a tremendous amount of speculation. There are all these people who offer these views one way or another, and people are very vocal about it. But it's important to empirically measure it and understand it, to be able to prepare, to be able to train students. I mean, I teach law students. I operate in the profession. And we need to know what these tools can do, what they can't do, what the benefits are, what the costs are. And we need to be, I think, empirically minded about that. And so that's just been a big motivator for me as I've been doing a lot of this work. I just think it's important.
Well, I think what's so important about this study as well, and again, another topic I'd love to talk to you about is how you, as a professor, control for students and how you use these types of tools in the classroom. But the next question I have really focuses on how you stay ahead of a field that's moving so fast. But it sounds like you're very focused on this human tech element so that there's almost like a deeper truth. So even as the technology evolves and grows and does different things, we're really focused on the impact this has on humans and the human tasks that we've done all these hundreds of years. But when you finish a study like this and the latest technology has already dropped before the paper even goes to press, what does that do to how you think about pivoting to the next study? Are you trying to stay ahead of the technology almost when you do these studies, or is there something different to it?
Yeah, I mean, that is a huge challenge of doing work in this space, that the technology that you're evaluating is always changing. But the way I think about it is what empirical work can do in this space is set baselines, right? So we know the technology is getting better, right? And so if we can establish that the technology as of this date was able to accomplish certain benefits, certain tasks, certain improvements in efficiency, that's incredibly useful because it gives us a baseline to say, okay, well, that's what it was then. We can extrapolate forward and we can see the trend line. And so that was part of why, I mean, even the two studies that I did, the AI powered learning study and then the one in the Minnesota Law Review, which I'm going to forget the name of because they're all similar. In some sense, were very similar studies methodologically. And really the main difference was the technology being tested. But we found really different things. With the earlier technology, that was GPT-4 that we were testing, we found that there were real improvements in the speed with which our participants could perform tasks, and there was sort of no change in quality, which is great and helpful to know. But then when we tested the newer generation, we found not only were there speeds and efficiency, but there were big, significant improvements in the quality of work too. And I'm sure we'll get to that in more detail. But now that that information tells us, okay, well, look, we have a baseline where now, at least for the types of tasks we were testing, we can be reasonably confident that using AI is going to make you faster and make you better at rates of about 30, 40, 50%. Now, I'm very confident those numbers are not going to get worse. And knowing that can have a lot of ramifications for how we teach law, how we structure law, what we think is going to happen to the legal job market, how clients should decide how to use outside counsel, even if things are getting better and we can know that and extrapolate forward.
Ray Kurzweil's singularity is happening in the legal profession, right? As we speak, we're creating super lawyers. And that's the really cool promise of the work that you're doing is I can't wait to see when we go through a few cycles of law students that come out of law school and move through the ranks up to partner, how it evolves the profession itself and how lawyers improve on all these different metrics over time and how the practice changes. But before we jump into the actual study, just to set the stage, run me through what surprised you the most. Talking about all the studies you've done, compared to your prior work, and not the improvements in the tech itself. Those are clear. But finding where you went into this study expecting something and the data came back saying something else. What surprised you the most?
On this particular study, what surprised me was we tested 6 different types of tasks, and most of them were more litigation oriented. There was a variety of reasons for that, but we also had a more transactionally oriented task that involved drafting a non-disclosure agreement. And our results in this particular study was that there were significant improvements in speed and quality when folks used AI for 5 of the 6 tasks. But the 6th task, the NDA, the transactional task, we didn't find that effect. Now, I have lots of theories about why that is, and I still don't really think the reason for that is because AI is less helpful in a transactional setting. I actually think in many transactional settings, AI may be more of a game changer than in the litigation context. But that was surprising to me, right? I expected that, if anything, AI would be more helpful in adapting a non-disclosure agreement to a new setting than it might be, say, in writing a legal research memo or in drafting an email to a client. And so that was a surprising finding in this particular study.
I would almost like to see that compared against a lawyer who's not working off a template, like maybe if they're working from scratch versus the template. But then again, then that gets us into our competency skis. As a lawyer who normally doesn't know anything about these types of agreements, drafting things based on using tech, and they're not really good at evaluating that if they're not working off a template. Let's jump into the basic architecture. So let's put that on the table for our listeners who have not read the paper. Everybody, that's your homework. Read the paper. It's a good read. 2 AI tools, 137 students, 6 tasks. Walk us through this design, what each participant actually did, how were the conditions assigned, and how you graded the work. Talk to me like I'm a 10-year-old in terms of how this is structured.
Yeah, absolutely. So we, as you said, we had about 135 or so participants. They were second and third year law students, either at the University of Minnesota or at the University of Michigan. And we split them up into 3 groups. And those 3 groups, we tested or randomly assigned. So roughly we expected in general, in the aggregate, they'd perform about the same. And we were able to sort of test that by looking at metrics like how did they do in their grades? What type of LSAT scores did they have, et cetera, et cetera. Once we had our 3 groups, we developed these 6 assignments, and we developed these assignments in partnership with a bunch of lawyers out there to be realistic for what a junior associate, a junior lawyer might do. Because, of course, we didn't have senior lawyers and we weren't able to test that. And so we thought, look, second and third year law students are reasonably good proxies for junior lawyers. I mean, they act as junior lawyers in lots of settings, whether it's law school clinics, whether it's summer associates. And so we wanted tasks that were appropriate for that level of experience. And so we devised those tasks. And I've already alluded to some of them, right? Adapting an NDA, drafting a complex research memo, drafting a client email. We had a number of others that involved more persuasive writing and so forth. And we have all those assignments in the appendix of the paper. And then what we did is we were testing 2 AI tools. So the very first AI reasoning model that was out there, which at this point seems like forever ago, but it was O1 preview. And just as a reminder, a reasoning model, one way of thinking about it is instead of just outputting an answer immediately, it generates a chain of thought where it sort of thinks, in air quotes, thinks through its answer and it goes down several trees and plans and then provides an answer. So there's more compute at the answer generation stage. Then we are also testing these retrieval augmented generation models that are using AI not just to generate answers based on the pre-training, but that also are relying on relevant source materials to produce answers.
So is a RAG model almost operating in a sandbox? Instead of going out to the internet for an answer, it's going to a law library.
Yeah, that's one way. That's a helpful way of thinking about it. Exactly. And so, for instance, the tool we tested was Vincent AI, and Vincent AI has a whole bunch of cases and statutes and treatises. And with a RAG model, you'll ask the AI a question, and it will perform a search, and it will evaluate the various sources, and it will find the most relevant sources, and then effectively it will use those sources to craft an answer. And so it's relying on these authoritative source materials of the type that a real lawyer would use. What we did is we had 6 tasks. We had 3 groups of participants, and we had 2 AIs. And so for each task, we had one group that was performing the task without AI, one group that was performing the task with the RAG model, and one group that was performing the task with the reasoning model, and then we just varied that by task. And so every participant had 2 tasks that they did without AI, 2 they did with the reasoning model, 2 they did with the RAG model. And so that allowed us to evaluate the extent to which, for any given task, the participants who, for that task, had, a particular model, how they performed relative to the participants who didn't. And so that was the basic setup, and to see what happened in terms of the speed with which they completed the tasks, and then the quality. And to evaluate the quality, we developed rubrics ahead of time of the type that one would use to grade law school exams or legal writing assignments. And we had some of our co-authors who had experience in the relevant fields grade the answers using the pre-specified rubrics blindly. And so they didn't have any idea whether the particular assignment they were grading was one that where a student was using AI or not AI, or which one. And so that allowed us to have pretty good sense of what the consequences were for our participants of using particular AI models or not using an AI model, both in terms of the speed and in terms of the quality of the resulting output.
If I can put on my adversarial cap as a lawyer real quick, these 6 tasks that you had, how do you control for the fact that you have 135 participants, they're doing 6 tasks, they're obviously attending 2 amazing law schools, so there's already kind of a base level of competence and knowledge and expertise that these folks have. But since they're randomized across the group, is there a residual concern that maybe one student is just better at one of these tasks than another, and that could meaningfully have an impact? And if so, how do you control for that in the study?
Yeah, so we wouldn't particularly expect, we had 3 groups of about 43, 44 participants, right? Whatever a third of our 135 participants was. And of course, there are some participants in some groups that were, better at particular tasks. But because we were able to randomize the groups ahead of time, we wouldn't expect ex ante that any one group was systematically better than another group. And we would, if we had that imbalance, we would have been able to see it statistically. So we would have been able to see, okay, well, this group A is much better in general than group B at these tasks. Then you would expect that group A is systematically doing better, whether or not the task is one with AI or a particular AI or no AI. And that's not what we found. We didn't find any systematic differences in how the groups as a whole performed across those different tasks. Instead, what we found was, not surprisingly again, because of the randomization, that the differences really were not large across the groups in terms of how they performed when they had similar conditions, but that there were significant differences in how they performed when they had these different tools. That's one of the nice things about a randomized control trial, because you can control every element of it and you can randomize who's in which group and you can structure it. You can get pretty good causal inference without having to worry that the explanation has to do with the fact that one set of students is much stronger than another.
And I do have to say, as somebody who is a history and communications double major from back in 2001, and who's of course become adept in technology over the past 2 decades, I don't often read empirical studies as much as maybe I should. They don't often come out in the legal profession like this. So the way that the study was drafted was really accessible. So I appreciate that. And again, I encourage everyone to read it. I learned a lot about task fixed effects and these different control mechanisms, and the way that it was done, I think, was brilliant. I'm looking forward to how the next studies evolve.
And I have to give a lot of credit to my co-authors on that one, because I too, I have some empirical chops, but not as much as some of my co-authors who really helped with evaluating some of the more complicated empirical elements. And so that's why it's important to do these collaborations where some, my co-authors were economists and had these sort of more sophisticated empirical techniques to supplement. And so I think that type of collaboration is increasingly important and necessary.
I want to push on something here, push on one button. There was a Stanford study from 2024. I think it was Magesh, if I'm pronouncing that right, looked at RAG-based legal tools and found in that study, if I'm quoting it properly, that they hallucinated a lot more than the tech vendors claim. Yeah. Your paper finds that Vincent AI users, that in those contexts, it hallucinated less than people working with no AI at all. And those 2 findings seem to be going in pretty different directions. So how do you reconcile those 2?
I think this goes back to the question of, we were looking at what happens when humans use these tools. And they were just looking at what happens when they try to prompt these tools, often in ways, frankly, that were sort of designed to produce hallucinations. So in that study, they would ask questions like, tell me about the dissent that Justice Ginsburg wrote in case X. And then the AI would say, and the dissent that Justice Ginsburg wrote in case X. And then it was like a trick question because Justice Ginsburg didn't write a dissent in case X. And so they were trying to elicit hallucinations, at least in part in that study. And what I would say is that the hallucination risk associated with these tools depends on how they're used. And it depends on how humans are using them. So one is just you may be prompting it and using prompts that are not likely to elicit hallucinations. But then the other thing is a huge part of the power of these tools is not just the output they produce, but that they facilitate the ability to check the veracity of the output that they produce. And so most of these tools, including the tool that we use, will provide the citation, provide a link to the underlying document, make it easy in a sort of a split screen to see the original text and to verify. And so that, to me, is the more important question. Not, in theory, can you get these tools to hallucinate? And I think the answer there is, in theory, yes. But in practice, if you're using these tools in a way that's sort of consistent with how an ordinary, reasonably well-trained lawyer would, are you frequently going to fall prey to hallucinations? And at least in our study, we found that, it happened. It does happen, but it didn't happen terribly much with the retrieval augmented generation. And as you mentioned, it didn't happen anymore when people were using the RAG models than when they weren't using AI at all, at least in terms of how we defined hallucinations. There are different definitions of hallucinations. So we were looking not just at whether or not the underlying source material existed at all, but whether or not there was sort of a significant misrepresentation of that source material. And look, lawyers misrepresent cases all the time, even when they're not using AI.
even without AI, sure.
Yeah. And so we didn't find any evidence of that. Now, I would say, and this is as a caution, that wasn't our primary research question. And so the sort of statistical power behind that finding is much less than our primary question, which was really focused on the comparative quality overall of the work product, as opposed to the frequency of hallucinations. In general, the vast majority of work didn't contain any hallucinations at all. And so that means we were not able to sort of evaluate how frequently they occur. We'd need a much larger sample than we had in order to evaluate that. So I would say our study is suggestive on that point, but not as powerful or convincing because we didn't have that wasn't the main question we were focused on. That was in a sense a side finding we had.
I think what's important, I can ground that in the number of programs and CLEs and podcasts and things that you've heard about GenAI, which primarily up to this point have focused on the hallucinations and the horror stories around hallucinations. And I think when you look at the case law and these kind of crazy scenarios where lawyers have submitted hallucinated cases, it comes down to that lack of supervision, that lack of human interaction. If the Magesh study measures AI alone and yours is that AI plus human element and that makes it better, I think that maps to the best practice we always say, which is the obvious one of if you use these tools, you got to review your sites and make sure you site check this stuff and that it's working.
Absolutely. And look, that doesn't mean, as we're recording, it was only about a week ago that we had the news of Sullivan and Cromwell submitting briefs with hallucinated sources. And I was, look, even very good lawyers. And I think it's true, right? Lawyers screw up, humans screw up. But look, humans always screw up. There have been past times when Sullivan and Cromwell or any other great firm has misdescribed a case or had some bad arguments in their brief or whatever else. And I think AI use makes it just so much more obvious and like black and white that that's happening. I don't really think, though, that the risk of hallucinations is some fundamentally new risk. I think it's just the risk that sometimes there will be bad lawyering. And look, even the best lawyers sometimes engage in bad lawyering because we're all humans. And it just makes it much more obvious when that happens. So yes, it's a risk and it's very embarrassing when it happens, but is it a fundamentally new thing that should be deterring people from using AI? I don't think so. I think quite the opposite.
Yeah, and of course everybody likes the salacious headlines and whatnot, but at the end of the day, that's also the adversarial process is designed. If you engage in that, someone's going to catch it, right? So you're going to see it and it's going to come out. So I think almost you need some of these types of incidents to remind folks to make sure they're crossing their T's and dotting their I's. But in your paper as well, you're very careful about the limitations of the study. Law students aren't licensed lawyers. The tools that were used were already evolving. They might be a generation behind. Tasks, like you said, lean heavy on litigation. If you had to pick, what limitation in this one would you choose to change in a future study?
Well, I'm going to cheat on this one by giving you an answer that motivated the very next study that we did that just came out. Because the real thing that I worried about in this study, and that I think makes a lot of folks nervous about using AI, is that when you use AI, you become a less good lawyer, right? So maybe you produce work product when you're using AI that's better, but then once the AI is no longer available, all of a sudden you're at sea, right? So think about like using an AI to help you do legal research. And then you have to go talk to the partner and you can't explain that legal research. Or you have to go talk to the judge and you can't answer their questions because you used AI to help you write the brief. Or you used AI to help you evaluate a deposition, and then you're in a new deposition and you're not seeing connections between the two depositions that you would have seen had you done the actual work of evaluating it.
I can relate that to this podcast. So everybody out there who might think that I used AI to come up with these questions and not read the very dense, awesome empirical study, I read every single word of it. So I did use AI to read the study. So
there you go. Absolutely. I'm glad to hear it. So that was one of my big concerns, that in terms of the actual impact on the legal profession, that we don't know what it's going to be from the study, because people might reasonably be reluctant to embrace AI because they think, well, sure, it will make me better in this narrow way, but it will make me less good in this broader way. So in the more recent paper that I had alluded to, we tried to test that, and we used another randomized controlled trial, this one just consisting of University of Minnesota students. And to give you sort of the basic setup, we recruited about 100 law students, again, upper level law students, and we split them into two groups. And we had them read this dense legal source material and summarize it for us. And half of them were allowed to use AI to help them, and half of them were not. And then in the next phase, we had them apply all of that legal reasoning that they had read, all that law that they had read about, to an entirely new hypothetical. But neither group had AI. And the hypothesis we had going in was that for the group who used AI in sort of phase one to help them understand the legal source material, of course, they would produce sort of a better summary of that material than the folks who didn't. And we found that, and that was consistent with my prior work. But then the hypothesis was that in phase two, when no one had AI, that the folks who had used AI in phase one would actually perform less well at sort of taking what they learned and applying it in a new scenario, for exactly the reasons we just described. They would have used AI to sort of produce summaries, but they wouldn't really understand it very well. And so once the AI was taken away, they'd be like, oh, no, I don't have any understanding of what was happening, and I can't very well answer this hypothetical. And in that particular study, we found the opposite result.
Oh, wow.
So we actually found that our participants who used AI in phase one to help them sort of understand and digest the legal source material outperformed the participants who didn't use AI in phase one, even when the AI was taken away. Wow. And what the data suggested was that was because the AI in phase one really helped those participants deeply understand the materials. And once you deeply understand the materials, it turns out that has lots of benefits, even when the AI is no longer around, because now you have a more nuanced understanding of the rule.
That's really interesting. And it makes a lot of sense. Like, I mean, I just from using AI tools, I'm horrible at editing myself. I'm very long-winded. Any professor who ever graded any paper of mine, it's like I write too much. I've always been really bad. But as I've used AI and I've seen kind of the outputs and how things compress and summarize, I'm beginning to be a little more natural in doing that on my own. I would not have expected that. That's an extremely interesting finding.
I think it's really interesting. But look, it's still just one, and now it's another study. But I think there's actually a lot more work that needs to be done in this domain about how AI use affects legal reasoning. So for instance, even in this most recent study I just described, we were looking at short-term effects of using AI. And I do think there are a lot of concerns about, like, well, what about long-term effects? Because I think a lot of people have a different intuition than you, that if you're using AI sort of repeatedly for everything you're doing as a junior associate, then you're not going to develop over time the skills.
That muscle will atrophy a little bit, right?
Yeah. And so that's not something we were able to test. And even in the other study I mentioned to you, we were just testing one context. But I I think understanding how AI use affects, I mean, look, I think one of the most important questions in society today is how AI use affects reasoning in general. And there are studies coming out on that, but I think that it's a particular question how AI use affects legal reasoning. And I think on that point, really, aside from the work that I've done, I don't think there's really a lot of evidence out there. And so I think we need to do a lot more research on that. And that's sort of where I'm hoping my, research agenda is going to take me in the future.
Developing that point, there's a finding in your paper that I keep coming back to, that both tools that you tested dramatically improve writing. So clarity, organization, and professionalism were three of the factors that you looked at. But neither tool really improved accuracy, I think, in aggregate was one of the findings. And only the reasoning model improved analysis. So to go to your point about reasoning versus base writing, is it making lawyers better at lawyering? Or are we just getting better at writing? Or are we conflating those two things? Or is good writing good lawyering? It sounds like you want to get into that more, and this study may have some limitations there, but are we conflating those two things, or is it measuring?
Look, I think these are important questions. I mean, I think in the AI-powered learning study, what we found is that when folks were using the reasoning model in particular, the results suggested not only was the writing better, but like the underlying analytical quality, analytical depth was better as we assessed it blindly based on predefined rubrics. Now, one of the things that's a little challenging, right, is like this is an somewhat subjective question. How analytically rich and deep is this answer versus that answer? But again, because we were doing blind grading and because we had many exams, we were able to find a statistically significant effect when blindly grading. And so that to me suggests at least the output when you're using one of these more advanced AI reasoning tools is not just sort of better cosmetically, it's not just better written, it's better in terms of the analytical depth. And that makes some sense because, in fact, where the reasoning models excel is in sort of analytical depth, is in breaking things down step by step, explaining how one point follows from the next point, explaining how the different pieces of the argument fit together, considering sort of the nuances of the arguments. And so it makes some sense to me that the analytical depth was stronger when using that. Now, that just is a reflection of, okay, well the analytical depth seems to be stronger when you're using an AI as opposed to when you're not. The next question is, well, what happens when the AI is taken away? And that's what we're trying to get at with that latest study. But yeah, I think that a lot of these things are tied together. I do think that the quality of legal work depends on all these things. It depends on the quality of the writing. It depends on the professionalism. It depends on the analytical depth. And I think it's definitely true that there's some artificiality in trying to like segment these out and evaluate them. They're all highly overlapping, right? So if you see something that's better written, you're more likely to think it's analytically rigorous. But at the same time, I think that one can separately evaluate these things. Sometimes you see things that are beautifully written that you think, oh, maybe that, it just scratches the surface. And sometimes vice versa. You see some writing that's not very eloquent, but that, makes some really good points. And so we were finding effects across all of those different criteria.
I think what was really interesting, and let me push on the productivity numbers for a second, was on those reasoning heavy tasks. So the persuasive letter, memos, complaint analysis, which is where a lot of lawyers would, I think, argue that this is where true judgment really lives. You could read the data two ways. One is that lawyers are leaning hardest on AI where it matters most. And in that regard, folks really have to focus on ramping up quality control because we're leaning into using it where there's legal judgment being applied. Or that AI is really good at handling the writing and the structure, which has an ancillary impact of allowing lawyers to be freed up to do more of the legal reasoning. Which one of those two things do you think is closer to what you saw in the data itself?
I think it's hard to say, and I think part of why it's hard to say is because everyone uses the AI differently, and we weren't really able to get under the hood and how folks were using the AI. And I think that just really varies. It varies by our participants and it varies by tasks and it varies by their background. And so I don't know for sure, right, like which particular uses of AI, which AI strategies that we had were being used because we gave our participants a lot of freedom in how they used AI. So it's a hard question. And I think that's one of the things that is another important area for further research, right? Understanding like which strategies work best and which don't. The way I really like using AI, I like doing all of my own thinking, but then having AI sort of help me with the writing it out. And part of that is because, I used to spend all this time making sure that each sentence was perfect, and I would obsess about making sure I didn't have any, grammatical errors, of course, but also just sort of that the flow worked well. And I just feel like AI just makes that so much easier. And it does. It allows me to do, I think, more reasoning, because it means I don't have to like spend all my brain power on crafting the perfect sentence. So for me, that's a very powerful use case. But I think it's different for different people and it's different for different tasks.
What I think the beauty of this study is that usually when I read a paper, I leave with questions answered, and I probably have more questions answered than I want to ask, or vice versa. This one, I had a myriad questions answered and even more questions I wanted to ask. And I think for somebody like me who is much more lawyer heavy than tech heavy, it gave me a lot of the language to be able to push forward this conversation that the industry needs to be having right now. And I love that about this study, is that I had a lot more questions. I felt more informed and more curious about these questions that we're talking about here. And I think there's a deeper question sitting underneath all of this. This might be the most controversial one that I ask you up to this point.
Okay.
So if legal reasoning is fundamentally text in, text out, I mean, think about it. We think in words, we think in concepts, we think in language. It's all text, it's in books and whatnot. Facts plus precedent, that's what equals conclusion. If that's the case, and these technologies can evaluate text with the precision, the accuracy, and this pseudo-humanistic reasoning that they do, is there anything about lawyering that is really structurally protected from AI as we evolve into the future? Is the promise of the Cyberdyne robot lawyer there just maybe 100 years away? Is there something more than just writing structure and that textual analysis that's at play here?
Well, in answering this question, I want to start out by just being really clear that I don't know the answer, right? And so all I can do is speculate. I think it's really hard to predict the future when the future is moving so quickly. And I think some of these questions are actually not even necessarily specific to law, right? Like they really go broader than that, right? Is there something unique to human reasoning as opposed to artificial reasoning? Like these are very deep, difficult questions. That being said, I'm optimistic, and I'm more optimistic than I used to be, that there is going to be a continued role for human lawyers for a significant time to come, and more so than in even other types of professions, like accountants, say, or consultants. And the reason I think that, there are a few sort of elements, but at the end of the day, a huge part of it is we're not going to be willing to offshore our questions about what appropriate rules of the road should be to govern our society to AI. We as humans want to make those decisions. And a lot of law is about how we want to govern ourselves. And so it's not really about what can we do faster or better. It's about what are the rules we want to govern ourselves and our technologies. And so I think that's fundamentally, almost inherently, a question that we need humans to answer. I also think that we, at the end of the day, feel like we want humans to evaluate decisions. Like there's a big literature on procedural justice where people want to be judged and evaluated by humans. Even if an AI or a computer system is making, in some sense, better or more objective evaluations, part of the sort of litigation process certainly is about feeling like you were heard by a human. They listened to you. They understood you. They considered. And so I think we're not going to get rid of human judges. Now, if we don't get rid of human judges, I think human judges want to hear from human lawyers. And similarly, when it comes to the sort of counseling role of lawyers, I think clients want to have discussions with human lawyers about whatever it is, trajectory of their business or how they should evaluate the regulatory environment. So I think there's a fundamentally human element to what a lot of lawyers do. And then the other thing I'll just say is, there's just so much unpredictability because it very well may be that AI opens up the possibility, for instance, for a new type of legal work, right? It may be that it makes certain models more effective, right? Like you can do high-end legal work with fewer employees. And so you don't need to be in a big mega firm to do really complex litigation. It may be that you can actually provide legal services that weren't even feasible beforehand because of the economics, where you're, drafting wills for folks for, only a few $100s as opposed to a few thousand, because it takes you much less time. And so it opens up a new business model. It may be that it changes litigation dynamics because litigation's a fight. And when one party has bigger guns, the other party has to get bigger guns. And so it may be that it doesn't change at all how much time litigators have to spend on cases. It just means that they need to devote their time to different ways, to different types of tasks. And so there are just like a million of these questions. I've just named a few that just make it so hard to evaluate what's going to happen to the legal profession. But I think that what I will say is, at least as of right now, I don't think we've seen any indications that the job market for lawyers is softening as a result of AI. And, while that may happen in the future, I don't think it's going to crater for some of the reasons that we have been talking about. I think it's also the case that just AI raises a whole bunch of additional legal questions that are new, right? Yeah. And that gets back to the type of questions we discussed, right? What are our concerns about discrimination? What are our concerns about how to regulate AI? How do we deal with the risks of AI when it comes to chatbots, when it comes to agentic AI, when it comes to cyber, when it comes to government using AI? There are all these new questions that now we have to evaluate. So there's just so much uncertainty in this space that it's hard to really come away with firm conviction about how the practice law is going to change in the future and whether we will all be replaced by cyborgs.
AI is not voir direing a jury anytime soon, right?
Right.
So,
exactly.
And I think there's a misnomer even in my question, the notion that just because you can take text and break that down into a mathematical algorithm for purposes of doing things like GenAI retrieval or TAR, things like this, doesn't mean it goes the other way. And I think there's proof in that. You can enter the same prompt into two different tools, or even the same tool twice, and get different responses back, right?
Yeah, no, absolutely.
So there might be an interesting benefit of all this, that the human element of the law comes out even more so as these tools get more sophisticated. But going back on this topic into your paper is full of a very carefully hedged language. But the moment that a study like this gets out into the world, that hedging kind of gets stripped away. And I think you're going to see a lot of claims made and people kind of adapt things to whatever benefits their own purpose.
Of course.
I think you're already seeing findings that kind of might even overstate certain things. What's the version of this study that you do not want practicing lawyers to walk away with?
That people should always use AI for everything, reflexively, without sort of evaluating how it's used and when it's appropriate to use and what the risks are. I think there's still just a lot of questions that we need to evaluate. And while it's definitely true that there are a lot of contexts in which we should be embracing AI, and I do very much think that every law firm and every lawyer needs to be asking those questions, I still think that caution is sort of warranted in many contexts. And so I think that's the big cautionary note I would have for readers.
So Dan, before we jump into the ESI 5, last question, and I want to leave the audience with something to sit with. And I love how we've arced in kind of this kind of philosophical space, if you will. And this, I think, ties in a few things that we've talked about. But legal practice has always used some level of surface level competence, clean writing, punctuation, attention to detail, clean citations as kind of this gateway. I mean, arguably even the bar exam, right? So the associate whose memo was formerly full of typos wouldn't get the next assignment. And the student who can't write a clean sentence in your class doesn't get to the reasoning part downstream. It's been a filter for as long as the profession has existed. I think the study shows maybe AI, maybe I'm overstating this, might remove that filter, and it can help maybe weaker writers level up and close that gap with stronger writers. That gap compresses. So there's two readings of that. One is that filter was always proxy for the privilege of being in the profession. It makes the profession more meritocratic, if you will. Or two, the filter was always really training a real set of virtues. Are you precise? Do you have attention to detail? Do you have a capacity for self-editing? And removing it, maybe does that create a generation of lawyers who, like we said before, don't ever develop those virtues because the AI did that for them? As both a law professor and a researcher, does that worry you? And if so, which one are you more worried about? The gatekeeping aspect of the profession going away, or lawyers going further down into the profession without having those skills?
I think it's a really good question. And I have a lot of concerns in several different directions here. I mean, One thing in terms of the gatekeeping function that you mentioned is there is a lot of evidence, there's just evidence that came out a couple weeks ago that what we're seeing is a pretty radical transformation in pro se filings, where a lot of pro se filings these days are now increasingly looking semi-professional and harder for judges to sort of dismiss early on. And I think that's going to place huge pressures on courts and on judicial systems because they are built on the assumption that gatekeeping makes sure that we don't have people flooding the court systems with non-meritorious claims. I think nowadays it's becoming increasingly hard for judges to sort of just dismiss pro se complaints that don't meet basic plausibility standards based on how they look. And I think it's hard for judges. Now, is that a good thing or a bad thing? It's probably both. Right? I mean, it's great that we're increasing access to the courts, but at the same time, our courts are based upon some of those frictions that you mentioned, that you can't just easily go and file a complaint in a court over something that's trivial because it takes time and effort. And well, now you can. So what does that do for judicial systems? Hard question. I also think it's true that AI means that it's much harder to go on a simple proxies for quality. And you say, oh, well, look, this is reasonably well written and it looks right, it's formatted right, it must be reasonably competent. I mean, I think that's like probably a reasonably accurate way of thinking in the past, but I don't think it's true anymore. And so I think it's incumbent upon our profession and all the action to like do the hard work saying, like, is this actually good or not? Right? It's not enough that it looks good. It's not enough that it has the form of something that's good, but like you need to evaluate the actual quality. And so in some sense, I think that's better because I think sometimes relying on those proxies for quality, whether it is the blue booking, it produces a lot of wasted time. And two, it really is a very noisy signal. And so I think that in some ways that's great. In other ways, it makes life harder. And so again, how is that going to net out? I wish I knew. I wish I knew.
That pro se point is very interesting. I wonder if you're going to start seeing judges with these hyper local rules where you have to use the green cover sheet if you've used GenAI in your filing. And again, it then harkens back to what we talked about at the very beginning of our discussion. Can a judge evaluate effectively someone's ability to represent themselves, knowing that they're using these tools that might put them out ahead of their competency, right? Yeah. So, well, with that, Dan, we're going to jump in to what we call here on ESI Survival Guide, the ESI Five. So this is a rapid fire set of questions. The more brevity, the better, but feel free to, of course, answer as you wish. ESI 5, question 1. If you could only run one more legal AI study in your career, one more randomized controlled trial, what would you want to test?
The long-term impact of using AI on skill development.
ESI 5, question number 2. Insurance law, as you said, is famously about predicting and pricing risk. What's a legal AI risk that the profession is currently underpricing, where we're going to look back on 5 years and wish we took it more seriously?
That our institutions that have gated volume by sort of ability to produce text are going to break. Our core systems are going to break because it's no longer the case that being able to produce text is a meaningful constraint for most people.
ESI 5, question number 3. What is one piece of technology other than your phone that you cannot live without?
Am I allowed to say my computer? Is that cheating? I want to say my computer.
Okay. No, that's it. That's the rules. That's good. Okay. Fair enough. ESI question number 4. If you could not be a law professor, if you could not be a researcher anymore, you couldn't write, you couldn't teach, you couldn't run studies, what would you do?
I'd be a judge.
Good answer. That's the correct answer. ESI 5, question 5. From a science standpoint, and this is the question I think people most want to hear from you on. What's more likely? Aliens, so we're going into astrobiology, ghosts, technically a physics question, or Bigfoot, so zoology. So we just did a bigger arc of science there. Which one's most plausible and why?
Oh, for sure, aliens. I mean, how big is the universe? Now, whether if you're asking whether aliens have actually been here, that's a different question. But I'm reasonably confident there are aliens out there somewhere, given the expanse of the universe.
Knowing as many lawyers as I do, I would argue that aliens are already walking among us. But
Fair enough.
But with that, Dan, thank you so much for joining me. I cannot thank you enough. Listeners, the paper is AI-Powered Lawyering, AI Reasoning Models, Retrieval Augmented Generation, and the Future of Legal Practice. It's in the Journal of Law and Empirical Analysis. We'll put a link in the show notes. Dan, thank you so much for joining us.
Yeah, absolutely. Thanks for having me.
If you found this useful, please hit like, subscribe, and consider joining the ESI Practitioner Pass at patreon.com/ESI Survival Guide for full episode resources, frameworks, and follow-up materials. This is Matt Knopf with ESI Survival Guide. Stay safe out there in the electronic wilderness.